Hello and welcome. My first task here is to correct an error in my previous introductory presentation. From that fact alone, you may deduce that I am not cut from the type of cloth which cloaks politicians, for as we are all aware, they never admit mistakes. Whether this is because they are bound by party loyalties, which ought not to override their commitment to the truth, but all too often does so, or whether they are psychologically incapable of facing what they imagine to be the utter humiliation of admitting, as the rest of us all do from time to time, that we got it wrong, is somewhat beside the point. It may very well be a highly relevant point, however, that inability or refusal to ever admit a mistake goes a long way to rendering a person basically unsuited for public office, given that these people often make decisions which affect millions of people's lives. Obviously, if a mistake is made and cannot be corrected because of some aberration in the personality of that official, the bad results can be amplified to produce most unseemly outcomes. But I digress. The error was referring to Vladimir Lenin as the author of the statement about whoever controls the money supply of a nation needing not to concern themselves with whomever is making the laws. In fact, that remark was made by Mayor Anselm Rothschild in 1790. I thank the person who alerted me to this mistake. I was going to proceed from that point to discuss exactly what I meant by the fraudulent financial systems operated by the criminals who have controlled our banking for the past few hundred years. But in light of the current political and social dislocations in our society, I propose to defer that discussion to a later time. Instead, let's turn to a topic which is affecting millions of people in Australia: the wholesale violation of basic human rights being inflicted by our governments, state and federal, which impact very negatively upon the well-being, both financial and emotional, of us all. Let's take a recent example of an event that involved me, but which is being repeated countless times across Australia. And let's discuss that and the legal ramifications of such happenings. I entered a store the other day in a large shopping mall and began to browse the display. I was asked by a lady behind the counter if I would don a face mask. I have legitimate medical reasons for not doing so. But of course, these are not the business of anyone else, as they form part of my private medical record. I explained that to the lady, but she insisted that I reveal this information to her, claiming that it was a legal requirement to do so. I further explained that this was not so, as there were several Commonwealth or federal laws which make it highly illegal to make such demands, which constitutionally override any such state laws or directives. And I even began to show her references to one of the relevant laws. She dismissed all that and ordered me to leave the store. At the time, I didn't have time available to continue the argument, and I left, but not before getting her name and rank or position, and informing her that I would be reporting her infractions, which process I have since begun. I have no doubt that had I stayed on site, the lady would have called either the Centre Management Security or the police, meaning the state police, and the situation would have escalated from there. So what are the implications of such a situation, and what is the best course of action to take? In other such examples, I have stood my ground. The police have been called, and usually the situation is resolved by the time they arrive. On several occasions, a small amount of documentary evidence has been sufficient to cause the vendor or proprietor to back down and wisely obey the law. On another, the police were called, but before they arrived, I had persuaded the staff to twice call their head office and pass on some of my information, and the head office had told the staff to treat us the same as any other members of the public. But that is not always the case. Another time, the manager called the police and asked me to wait outside the store while my shopping partner finished their business. I refused, waited inside, and was ready to confront the police upon their arrival when the shopping was finished. We therefore left and gave the police a cheery wave as we passed them on their way to the store, where hopefully they might have advised the ignorant manager to stop wasting their time with reports about people who were not causing any harm and who left peacefully in their own good time. As we can see, if we stand our ground and stick up for our rights, we win some and we lose some. But we never really lose because we can always report the offenders to the Commonwealth agencies, which are appointed to deal with these cases. It is best to remain as calm as possible and let the other person present their case without interruption. Not always easy if, like me, you possess some Gaelic or Celtic blood. Then respond with a clear statement of fact, trying to indicate that you don't really want the person to get into trouble, as in many cases they are merely following orders given by their bosses. But as we know, I was just following orders doesn't cut it for a defence anymore. So we can try to encourage them to get their heads around that idea and get them to just check with your boss if they're going to cover your $50,000 fine if it comes to that. You would be wise to see if they're going to back you up on this, don't you think? It's only a phone call after all. If we can get the staff to feel that we are on their side against the boss who is asking them to break the law, we can often overcome their initial resistance. The laws which cover these situations, the Biosecurity Act 2015, the Privacy Act 1988, and the Disability Discrimination Act 1992, all cover any of the unlawful mandates about any medical procedures, such as masking, testing, contact tracing, and injections. But what if the police are called and arrive? At that point, we should begin recording, if we haven't already started, and get the names and numbers of the police officers. We can point out that this is a civil matter in which they have no jurisdiction. Police may only insert themselves into a situation where they suspect a crime has been committed or is about to occur. Our evidence that this is a civil federal matter is the simple fact that if the business has an ABN, it obviously comes under corporate law, which is federal. All such laws apply to the whole of Australia and do not vary from state to state. Therefore, remaining calm is important. We don't want to give the police any opportunity to nominate a breach of the peace, etc. We can also assert, quite correctly, that it is we who are reporting an offence, namely the infringement of several federal laws, but that it is still a civil matter. The proprietor, on the other hand, cannot nominate a law which we have broken, which means that even if the police are misguided enough to end up issuing a fine for some imagined infraction of the law, It will not hold up in court. Unless the proprietor or their employees have attempted to forcibly eject us, no assault has occurred, and we are happy to have the officers there to witness that this is a simple, peaceful exchange of views, which will be dealt with by federal authorities in due course if necessary. We can point out that if the police themselves attempt to forcibly remove us or arrest us unlawfully, that they are breaching federal law and may expect charges to be laid on themselves. In particular, Section 83.4 of the Criminal Code Act 1995 provides for a jail term of up to 3 years for anyone, police or otherwise, who uses any force or issues any threat whatsoever, e.g. arrests, fines or assault, to prevent any citizen from exercising any of their constitutional rights, such as freedom of movement, going about their shopping, and so forth. The police may laugh off such warnings, but just reminding them that this whole process involves heaps of paperwork and questioning by superior officers, etc., may be enough in some cases to defuse the situation. But if they do exceed their powers, we absolutely should follow that up with the filing of charges and prosecutions, etc. I have started carrying a short statement to read to police, if the occasion arises, where they attempt to insert themselves into one of these situations. This is part of the instructions given to police regarding the carrying out of their duties. Quote, "A constable has independent authority to exercise his or her office. A constable cannot be directed by the government or senior police as to who he or she should prosecute. A constable's duty to enforce the law is a personal responsibility, and the constable is answerable only to the law, not to his or her senior officers for the performance of that duty." End quote. These guidelines can be useful in many situations, including those encountered at rallies and other public events where we may interact involuntarily with police. But perhaps one of the most important considerations is the advice given me by an ex-policeman who urged me to pick the battles you can win. In other words, if confronted by someone who is clearly irrational, or a police officer who seems bent on finding an excuse to assault us, which thankfully seem few and far between here in WA, it might be best to avoid a direct confrontation or withdraw from one, but nevertheless record names, numbers and ranks for use when the odds are in our favour, when we are reporting offenders to the relevant authorities. Another thing we should all be doing whenever possible is to engage with individual police officers in quiet conversations. This can still be done even if they are in the presence of other officers. Some of us have tried this and have found that the officers will mostly listen politely, especially if spoken to in a manner that is non-hectoring but conversational. We can point out the statements about their duties mentioned above. We can also point out that once they have been informed of the crimes being committed by the government and in some cases their superior officers, that they can no longer claim ignorance, and that when eventually enough people are so aroused that the numbers resisting swell to the point where there are not enough police to contain everyone, that there will come a tipping point, as has happened in other tyrannical states, such as Chile, Argentina, Romania, Serbia, the USSR, etc., etc. There comes a point where even the secret police or top echelon enforcers realise the game is up and further repression of the people will have negative personal repercussions, and they stand down or join with the resistors to topple the oppressors. Calmly explain to these officers that while they may feel invincible in gangs of 50, 100 or even 1,000, while armed and confronting unarmed citizens, that lawful arrest warrants have been issued for the ringleaders of this criminal repression, and that eventually these will be actioned, either by the police doing their jobs or by numbers of citizens so large that no amount of police will be able to withstand them. At that time, the names of all police being a matter of public record, those who have facilitated these crimes or failed to act in the independent execution of their office, having been notified of the offences, will be required to give an account of themselves before a common law court as to why they should not be convicted for complicity. They may feel safe in numbers presently, but they can also be arrested after a knock on their doors in the small hours when they don't have the backing of other armed office offenders, by duly authorised common law sheriffs, or even by fellow police officers who have decided to honour their oaths. When police decide not to act lawfully, they need to be able to look over both shoulders. Ask them to seriously consider these questions and their relationship with their oaths to protect the people. There's no need for these conversations to be threatening. We're simply illustrating that this has happened time and time again, and it would be sensible for them to consider the possibilities, and especially for them to have conversations with their fellow officers about the likely long-term outcomes of their behaviour. We know that many police are unhappy with what is going on, and we need to move them in a non-confrontational manner towards the point where enough of them refuse to obey illegal or unlawful orders that the continuation of this oppression becomes untenable for them. It is possible, despite our best or most sagacious efforts, to still find ourselves on the receiving end of a putative fine for non-compliance with a null or void political directive or mandate. In this case, the best option is to delay a court appearance for as long as possible. Keep asking for postponements or adjournments for various reasons. The time thus gained should be used to get familiar with Article 61 of the Magna Carta and learn how to remove ourselves from the jurisdiction of treasonous governments and their acts and statutes. When this is done effectively, it is never necessary to go into a court of law, and any such demands can be negated before the starting gate. But that's a whole other story for another presentation. Thank you.